This is Paul. I just got to the study room here about 4 minutes ago. It's 2:16. Yes. You know, I spent some time thinking about this concept of evidence. And I had mentioned Exhibit A, yes, where there's this right here. But then I noticed that Bruce Hannafy had attached true and correct copies of the permanent protection order entered on July 31st. Notice of service made on August 15th. Yeah. But I never saw those. You know, when you attach true and correct copies of the permanent protection order, yes. And of course, I don't see them. For some reason, nobody wants me to see any of the evidence. I wondered if it's the same as Exhibit A that Jack had admitted to the court as evidence. Yes. The Exhibit A that doesn't have the forgery of the ex officio Superior Court clerk. Now, we're having a problem with what's known as true. True, yeah. And correct. Ooh, ooh. Now, I've been going to court numerous times because of what they would say is evidence. But my concern is that each time you arrested me, yeah, it's for a protection order that the petitioner didn't sign. I was not given any notice or opportunity to be heard. See, I put a picture of my own signature as the protected person. And then I put a signature on the state court seal. Yes. But as I've done so many times, you say that this is the same signature. Is that the same? Is this the same as that? Ouch. Now, I just wanted to make sure that when you have court hearings, there's what's known as evidence. And I know I'm not an attorney, but I think that irrational, inadequate, arbitrary, yes. See, I put my own signature there. Now, when you really look at it, I put a signature there as the petitioner. Then I said, inadmissible evidence may not serve as grounds for a court decision. Yeah. Inadmissible evidence, evidence that is not admissible. Now, a court shall decide the admissibility of evidence, and I'm sure that Judge Porter did read the protection order. Didn't you, Judge? Did you read it? There is no signature of the protected person. The state court seal is being used to say that in testimony thereof, I have hereunto set my hand and affixed the seal of said county. Yes. Now, the fraudulent use of any of the state of Washington seals, yes, that can't be admitted as evidence. Now, I did ask Judge Landis to read the protection order, yes, and she said we're going to admit it as evidence. Now, you're complicit in the crime of fraud. And I'm going to talk to you about evidence because I think that I have a huge lawsuit with this admitting of evidence that a court decision shall be reasoned. Now, let's say you're a judge, any state of the United States, and you say, well, this is evidence, yes, but it doesn't have the name of the petitioner, yes, has no date of birth, there's no name of the respondent, yes, there's no date of birth. This is order to surrender weapons, right? This is the district court number, yes. Now it says the person had actual notice and opportunity to be heard, yes. And I know you're saying, well, he's already gone through that. The problem is the admissibility of evidence. That you're using this as evidence. It says here on page 4 of 6 that the respondent had actual notice. Yes. represented a credible threat and was an intimate partner. Now, you're admitting this as evidence that I received actual notice that I represented a credible threat, and I was an intimate partner. You admitted as evidence Exhibit A, Jack. And Exhibit B, Coach. You admitted as evidence these dockets where I did not receive actual notice of court hearings. Yes. And you refuse to acknowledge that there has to be valid, non-fraudulent, yes, actual evidence when trying somebody. It says here, the clerk of the court shall also forward a copy on it before the next day, which shall personally serve the respondent. Now it says the county sheriff's office, right? It says the police department. I happen to live in Port Angeles, yes. And you were to personally serve the respondent with a copy of this order and shall promptly complete and return to this court proof of service. Yes. It says proof of service. Yes. Now, I didn't see the copy of the proof of service that Bruce Hanafy had. Poach. Now, was it that it says here correct copies? And the notice of service made on August 15th. Yes. I just wanted to know the notice of service, was that from the sheriff's department? Was it from the Sequim Police Department? Because when I was served in the Sequim Public Library, yes, if the actual true and correct copies of the notice of service, yes, and the permanent protection order, right, do not have the forgery of the ex officio Superior Court clerk, yes, if they don't have the fraudulent use of the actual state court seal, yes, and if the notice of service that you say is true and correct right now is not the actual personal service of the individual that served me in the Sequim Public Library, coach, it's a fraudulent. Now, I know I already talked about, but we're talking about the admissibility of evidence. Evidence. See, you said in this statement, I certify under the penalty of perjury of the laws of the state of Washington that the foregoing is true and correct. These are true and correct copies of the order. Yes. This is a certified statement from the public defender's office. Now, I got, right now, okay, I'm going to see the fucking shit.